Hello, everyone. My name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. I want to thank you for participating in today's community conversation, New Election Laws and Required Procedures. ECHO is a statewide nonprofit association established to support HOA boards and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, networking, and advocacy. For today's event, we have a few housekeeping items. These are presented on the screen, and the slides were also sent to registered attendees beforehand. Please take a moment to review our housekeeping items. We have a large number of HOA attendees today, which usually means a lot of questions. We will do our best to answer them. There will be a Q&A session following the presentation, and we will be answering some questions in writing during the presentation. Please keep your questions general in nature. Questions about specific situations are better answered one-on-one. Please use the Q&A icon, not the chat icon, to answer your questions or make comments. You should use the chat feature to report technical issues and to communicate directly with other attendees in the webinar. You will find the navigation icon by hovering over the bar at the bottom of the page. Note the chat and the Q&A icons are the most commonly used during our webinars. To help us select the most relevant questions for this audience, please use the thumbs up icon found in the Q&A screen. Simply click the upvote icon to select your favorite questions. And now for our disclaimer. None of what is said during the seminar shall be construed as specific legal or expert advice from the speakers, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. Thank you very much. Today, we have several sponsors. Please join me in thanking our program sponsor, CID Consortium, LLC, and our Q&A sponsors, Eugene Berger Management Corporation and Pacific Interwest. Now, we will view a short program from our program sponsor, CID Consortium. Connor?
HOA board members are volunteers from a variety of backgrounds who face complex legal, financial, social, and maintenance challenges. CID Consortium LLC is proud to support educational opportunities for volunteer board members and HOA members. At CID Consortium, our purpose is to enhance your community living experience.
Thank you to CID Consortium LLC and to all of our sponsors. Our webinar today is New Election Laws and Required Procedures, presented by Sandra Gottlieb, Esquire, and Stephen Brindle, Esquire, from the law firm of Swedelson Gottlieb. Sandra is one of California's leading community association attorneys and a founding partner of Swedelson Gottlieb. The firm limits its practice to the representation of California homeowner associations, including condominiums, planned developments, and cooperatives. Sandra's extensive negotiating skill, acquired and honed throughout years of practice, has given her the ability to work with volunteer board members, association management agents, and opposing counsel to achieve intended results and to provide expert legal representation on association operational issues. In addition, Sandra's depth of experience allows her to help associations with many other matters of significance and importance to California homeowner associations. Stephen Brindle is a senior associate attorney at Swedelson Gottlieb. He was born and raised in the San Francisco Bay Area and earned a Juris Doctor degree with honors from Golden Gate University School of Law in San Francisco. and his Bachelor of Arts degree in literature from UC Santa Cruz. Stephen represents and provides counsel to community associations on matters ranging from operations, corporate governance and governing documents, enforcement, short-term leasing, assessments, demand letters, dispute resolution and settlement agreements, and transactional matters. Stephen, please begin.
Thank you very much, Dave and Connor. Thank you for having Sandra and me today for this presentation. This is a very important topic, and when Sandra and I were going over this, we just realized how much information there really is in this area of the law right now. The laws regarding elections were significantly changed, as we'll see in the second slide, Connor. So as most people are familiar by now, the legislature in 2019 enacted Senate Bill 323. And in one fell swoop, this changed 6 different sections of the Civil Code regarding elections and added, 7 different sections and added 1 new section. This was a bill that, frankly, most people were not exactly clamoring for. There was a lot of debate about it, whether it was really necessary, whether these changes were going to be beneficial. But either way, it's the law now. And over on the right, you can see all the different areas that SB 323 changed election rules. And we're going to go over each of these a little bit more during the presentation. But to start with, some of the 3 biggest ones are procedures regarding nominations for candidates to the board, required contents of election rules, and who can serve as an inspector of elections and what their duties are. As we'll see in the next slide here, Connor. So one of the biggest changes is that many associations already in their existing, usually the bylaws, will say who is eligible to be a candidate or to be a director for the board. SB 323 changed the law and says that now there is only one mandatory qualification that an association must have, and that is an association must disqualify somebody from nomination if that person was not a member of the association at the time of the nomination. A lot of the bylaws will have many different other qualifications, such as you have to be a full-time resident, you have to be a member in good standing, you can't be in violation of any rules. And many of those are just no longer enforceable. But the only one that is mandatory, of course, is that you must be a member. And if a board is going to disqualify someone, they have to offer that person IDR, internal dispute resolution, prior to the disqualification. There is one exception for developer controlled boards because they often will have non-members of the association on them. But then, as we'll see in the next slide, SB 323 did still allow several permissive qualifications as long as they are either in the bylaws or that association's election rules. Because these are listed in the statute, most people believe that these are the only additional qualifications that can still be enforced. If they're in the bylaws or the election rules, the candidates for the board can be disqualified for being delinquent in payment of regular special assessments. If the person who's nominated would be serving on the board at the same time as someone who is already on the board. In the next slide, if that person has been a member of the association for less than 1 year, if that person has a past criminal conviction that, if they were elected to the board, could possibly cause the association to not be able to still maintain its fidelity insurance. This was a big concern that was debated in terms of, if we remove all of these qualifications and none of them are enforceable, what happens if we get somebody on the board and then the association's insurance company says, you have a convicted felon who stole money from their last employer or a bank, and because of that, we can no longer insure you for your fidelity insurance. So if the association becomes aware of one of those convictions, as they can disqualify that person again if they have that as a qualification in their bylaws or their election rules. And then starting in 2022, a new one is term limits. Many bylaws do have term limits for board members, but because they were not expressly allowed before, most practitioners took the position that they could no longer be enforced. But now the legislature has thankfully made that clear that it can be enforced as long as it's either in the bylaws or in the election rules, which Sandra will speak about. Go ahead.
I want to speak to one thing about if the association would be prevented from being able to maintain its D&O and liability, its fidelity insurance, then the association could say that past criminal conviction bars the owner from being on the board. The problem that we have is that in all the years, and there's a lot of them that I've been doing this, I only was able to get a carrier to say one time having that person on the board will result in not just non-renewal, but also cancellation. And that person had been convicted of an embezzlement felony from a governmental agency and spent time in prison. So that was the only time. So I'm just worried operationally that we're not going to get the information that some board members think that we're going to get as a result of this law, and they're going to be able to use that to disqualify people. It's an exercise that you have to engage in by actually asking the carrier, would this in any way impair that fidelity binding of the fidelity policy?
Right. And so that's just a question of calling up the association's insurance agent, whether that's the board doing it or the management company doing it, and saying, look, we have a candidate for the board who we are aware has this criminal conviction. If they are elected, would we still be able to maintain our insurance? And then relying on whatever the answer is.
Excellent, and I agree. So Connor, we'll go on to the next slide about election rules. We are going to be having a lot of slides on election rules and inspectors of election. So the election rules need to require retention of the association's election materials. Election rules are required to be a standalone document. So if you're taking the position that you have information about your elections and the association's CC&Rs and that's good enough, you're wrong, it's not. And the statute requires you to actually to do this. When we're talking about the retention of association election materials, the following things are included in that definition. So it's the candidate registration, a voter list, the signed voter envelopes, the secret ballot, the proxies, the tally put together by the inspector, and the tabulation. The association shall offer for inspection upon demand by an owner the election materials for review or copying by the owner, except the election ballot, the signed election ballot, so that's the exterior envelope that identifies the owner, may not be copied. And that's a public policy decision, obviously, to protect somebody's signature, to make certain that, in fact, their signatures are not improperly duplicated. In the next slide on election rules, we also, Connor, I'm getting a bunch of texts and emails that people are trying to get in and are unable to get in. So I'm not sure what the problem is on that, or if there's a problem, but they think it is. So I'm just telling you.
I will handle it on my end.
Thank you so much. So election rules must do a couple of prohibitions and a couple of requirements. So there's a prohibition of denying a ballot to a member. So previously, if somebody was engaged in conduct that resulted in a disciplinary action, the board of directors could fine them, take away common area privileges, and keep them from voting. And you may no longer do that. It's not allowed. There's no reason that you could do so other than the one mandatory provision that Stephen talked about, which is that the person is not a member at the time when the ballots were distributed. Another prohibition is that the denial of the ballot to somebody with a general power of attorney. This allows somebody to operate on your behalf. I will tell you that most of the power of attorneys that are turned in at HOA elections do not meet the general power of attorney definition. The general power of attorney requires the person who has the power of attorney to make decisions concerning the real property, meaning to buy and to sell. And I doubt that is the intention of the homeowner that gives somebody the power to vote for them at a board election, is also saying, oh, and by the way, you don't have to speak to me about it if you want to go ahead and sell my property. So be mindful of that. I'm not really sure that if the inspector said, I'm not really sure that this is a real general power of attorney. If it looks like a power of attorney, but for that fact, I believe that we're going to allow those secret ballots to be counted if it's turned in by that person, subject to that requirement. We also have a requirement that the person who has, and I just briefly mentioned this, the power of attorney gets to vote the secret ballot on behalf of the homeowner. So they get it and they have a right to vote it, and we can't say no. And then the fourth requirement is to require that the inspectors deliver or cause to be delivered the secret ballots to the homeowners no less than 30 days before the ballots are to be open for a vote. And also you must send a copy of election rolls, and that can be expensive. So this year, the legislature did some cleanup on the election rolls and said, if you have a place where anybody can access the election rules. So think the association's website, if you have one, somewhere where they can electronically or from a cloud retrieve the election rules, and you provide the owners with that information, you will be able to avoid having to spend the extra postage money on mailing out the set of election rules every time that you have an election at the association. So in the next slide, I'm going to start this long conversation about what the inspectors of election can do. So as you likely know, inspectors can no longer be an individual or a business employed by an association under contract with the association unless the contract is to be an inspector of election. And there was some language in initial drafts of this bill. It's because there was certain toward behavior that was being ascribed to managing agents, and really it was one or two homeowners that thought that was the case, and they went to their legislature. I'm sure that the people who are inspectors of election, who are doing a great job, loved the fact that a cottage industry was born out of this ridiculous, in my opinion, law. So if managers are no longer able to touch anything having to do with the election, we're not supposed to take in the ballots, we're not supposed to count the ballots, it really, in a certain sense, puts more of a burden on the board of directors. One of the things that we will say a number of times today is that we think being an inspector of election is too much work for a homeowner. And we're going to tell you why. Because the risk to the association can be great. But there's still things that the manager can do to assist the inspector of election. There was also some cleanup language this year about the inspector's assistant. So an inspector isn't one or three. Those are the numbers, one or three. But an inspector of election can have helpers, those persons that can help them open envelopes, run a tally, run a separate tally based on what the inspector is telling them when the ballots are reviewed. And they are now required to follow the same requirements that the inspector of election is, which is that they have to be impartial, not under contract, etc. So back to the manager. What can the manager do? The manager can assist the inspector in providing documentations, the governing documents for the association, information on recall elections and the election of the board of directors. These are all things that require the vote. So assessments requiring a vote, for example, if there is a special assessment as opposed to the board's authority to levy regular or emergency assessments. Also, the inspectors will be involved because we have to have a secret ballot vote for the grant of association common area. The statute does allow some grants without homeowner vote, but absent a disability accommodation or an area of common area that is not generally accessible to other owners, we are going to have to go out to a vote of the owners. So in training the inspector, the manager can provide, as I said, additional documentation. There can be forms, the tally sheet, the certificate of election, which is the report of the inspector, which Stephen will talk about in a moment. They can do the preparation for the election and scheduling for it. But the independent third party, if they're can be under contract to be an inspector, or they have to be a member, but they cannot be a director, somebody who is running for a board seat, a family member of a board member, or as I said, the candidate. So there's a lot of really strict restrictions All of it is to try and keep somebody from having this power in a conflict of interest situation to somehow influence the election. But there are some requirements about our elections and our inspectors that Stephen is going to start talking to us about on the next slide.
Right, and before we get to that, one of the changes that SB 323 made, which I think there was sort of general support for, is that now all associations have to have a board election at least every 4 years, and when a existing director's term is expiring. There were some associations out there that were just, the board was carrying over from year to year, and they just took the position, well, nobody ever votes in the election anyway, so why go through the whole process? You can't do that anymore. As the law requires you to do it at least every 4 years, or when a director's term is expiring, or when your governing documents require you to do that. Many bylaws say the entire board will be voted at the annual meeting, or they'll have staggered terms for the directors. And if that's the case, then that's what you need to follow. But if you want to take advantage of the new process of election by acclamation, which I've already seen a lot of questions about this in the chat, you have to have conducted at least one board election within the prior 3 years. So election by acclamation, what does this mean? This means that you have as many people, valid candidates for the board, as there are going to be open seats on the board at that election. And therefore, if certain things are met, the board, the association does not have to go through the whole rigmarole of actually conducting an election. The board can actually vote to seat those people on the board. Now, there would have been a split of it.
Hold on a second. Connor, can you please advance the slide?
Oh, thank you. There had been a split of authority about this for a very long time among lawyers as far as whether this was permissible or not. Some took the position that it was. We had personally taken the position that it was not, because of the way that the civil code read. In 2020, one exception was made for very large associations of 6,000 or more units, that they could conduct an election by acclamation. But because that was the only type of association that could do that, people understood the legislature saying, but if you've got fewer than 6,000, you cannot. Now that starting in 2022, you can. Election by acclamation is permitted for all associations, but what the legislature giveth with one hand, it taketh away with the other. Even though the whole idea of election by acclamation is to make things easier, to avoid the expense of having to print and mail and count ballots, the process for actually being able to conduct an election by acclamation is quite complicated. And it seems to be that the legislature worried that, well, if we allow associations to conduct an election by acclamation, people who would have otherwise run for the board won't, and therefore we need to protect their rights. So next slide, Connor, please. So there's a multi-step process here if you want to be able to conduct an election by acclamation. First is that you have to send out a notice at least 90 days prior to the deadline for nominations that says, here's how many board positions are going to be available in the next board election. Here's the deadline for you to nominate yourself or you to nominate someone else. Here's how you submit those nominations, and a heads up statement, which is what we call it, that if there are as many qualified candidates on the date that the nominations close as there are available seats on the board has the right to seat those people in an election by acclamation. Therefore, there will actually be no balloting. And this notice has to go out via individual delivery. This can basically replace the call for candidates that has been required for the last few years. But just be aware that if an association is planning on conducting an election by acclamation, the call for candidates that it was using before is probably not going to work. It's going to have to be sent out a lot earlier, and it's going to have to contain all this additional information in it. And it's going to have to be sent by individual delivery to all of the members. Sandra, you can talk about the second notice on the next slide.
And 90 days prior to the nomination deadline. I know you said it, but I'm going to say it again. What association, except very large associations, are even thinking about the next election at that point, let alone have all of this in process? So the next slide is yet more notices that have to be provided to the homeowners. So you were right, Stephen, what the legislature giveth, they taketh away, because they have added so many requirements to what should have been such an easy acclimation process. So the second notice is provided 7 to 30 days prior to the nomination deadline. And this has to require the number of board positions open, the deadline for submitting the nominations, how to do it to make the submission, and a statement that the board can vote to elect by acclamation. We'll talk about that further, but yes, it is, the board actually has to take a vote to vote by acclamation for the new board members to come in if we're not going to be counting the ballots. And we also have to include a list of qualified candidates running and requires individual notice. Again, individual notice currently is paper notice unless a homeowner specifically directs you otherwise. There's a new law, not part of this presentation, that during 2022, you're to be soliciting information from homeowners as to whether or not they want you to be able to use their email, whether or not they're willing to accept individual notice via email, and then you will be able to do so without person by person permission, which will be required in 2023. So again, what you're saving on counting ballots and working with a inspector of election, you are clearly, especially for larger communities, going to be spending on postage. On the next slide, Stephen.
Right. So in addition to the first and second notices that have to go out to take advantage of this election by acclamation process, there's actually a different process now for nominations themselves. So now, if within 7 business days after an association receives a nomination, either somebody nominating themselves or nominating someone else, they have to confirm in writing that they've received the nomination. They have to advise the person in writing whether that they are qualified or disqualified to serve on the board based on those mandatory and permissive qualifications. And if they are disqualified, they have to provide the person with the reason and a procedure for appealing that decision. Now, again, anytime you're going to disqualify someone, you have to offer IDR to them. But now, even after the disqualification, they have to have a quote unquote procedure for appeal, which I assume would also be an IDR, which does not have to be with the entire board. It could be with 1 or 2 designated board members. But the actual nomination process itself, to take advantage of it, is different. And so Sandra, on the next slide, we're going to talk a little bit about how the inspector helps the board with the whole acclamation process.
So we're going to call the acclamation process today, if you actually get there, to be the holy grail, because we are in a position where we are going to be able to vote by acclamation if you've met all of these requirements and you get there. And it's the inspector of election actually that determines the number of qualified candidates does not exceed the number of vacancies to be elected. So once the inspector says that, and once you've gone through all of the benchmarks and the notices that Stephen and I have discussed with you, the board at a noticed meeting can vote for acclamation so long as the qualified candidates' names were on the agenda for that meeting. Just a side note, you do all that, you get to this ordeal and you vote, and we could have an issue with whether or not the qualifications and the exclusions were warranted. Stephen talked about the IDR and the notice of appeal. I suspect this will be the single greatest issue we're going to deal with in 2022 and 2023 when associations try to assert the right to vote for vote by acclamation. Now we're going to go to annual meetings on the next slide. We're going to talk about the election rules, something that has to be in place before we even go down this process. So each association should have election rules. Civil Code section specifically requires that we do that. Remember, these are operating rules and they have to go out to the homeowners for a 28-day comment period. And then the board, in a noticed meeting on the agenda, will vote on the implementation and acceptance of those election rules. We like to do a little cheating here, and that is in order to confirm that we met that requirement, that we sent this out to the members, or we posted it by general notice, if you've designated in your year-end documents that you can post on the association property or a website or in the mailroom or the guardhouse if you're in a guard-gated community. We still recommend mail a copy of that notice to the corporation. Send it to the corporate address, do not open the envelope, and put it with your corporate records. So if somebody says you did not do that, we will have the proof that yes, we did. It'll be postmarked. We're not just sending it out now to respond to a homeowner's complaint that in fact we did not do this. And probably the most important thing is item number 3. Elections may not be scheduled within 90 days of approving new election rules. So if you have an election that is coming up, you want to change your election rules so they're better, but presuming that they are currently compliant with the law, unless you're willing to push back your date of election, wait until after the election to amend those rules. If you're talking about something that's a bit down the calendar way, then go ahead and do it, even if it means you have to push back your date by not a long period of time. Stephen, on the next slide, want to take us through some more of these rules?
Right. So more of the content that these SB 323 compliant election rules have to have in them, they have to list what the qualifications for candidates for the board and other elected positions are, which again are going to be that mandatory, you must be a member of the association, permissive, delinquent in assessment, not delinquent in assessments, not serving at the same time as another owner of the same separate interest, et cetera, et cetera. But if those aren't in the bylaws, or even if they are in the bylaws, they have to also be in the election rules. The election rules have to say what the procedure for nomination is, including the right of members to self-nominate. Everyone has had that right for a very long time now, even if you have a nominating committee, frankly. Excuse me. The voting power of each class of membership, which is really going to apply on newer communities where you still have developer control. You might have a class A and class B. The authenticity, validity, and effect of proxies. Proxies are frankly obsolete, but a lot of bylaws still, now that most elections have to be conducted via secret ballot, but many bylaws still allow for them. And so therefore, if the bylaws allow for them, you have to describe them in the election rules as well. And also the voting period, including when the polls will open and close. And by polls, what they really mean is when the ballots are going to be mailed and when they must be received by the inspector for tabulating. And then so Sandra, the next slide there's even more content that the election rules now have to be compliant.
So there has to be a method to select the independent third-party inspector. As I said, it's 1 or 3. You can do that by appointment of the board or election by the members. Yes, you can do it by election of the members. I can't imagine why you would ever do that because you have yet another election to select an inspector of election. It just seems like a really difficult and expensive way to select an inspector of election. The inspector, as I said before, can appoint and oversee people to help verify signatures, count and tabulate votes. And they do that in the way that the inspector thinks is the most productive. The inspector can call out the vote and you can have 2 people tallying the votes, and then we make sure that their tallies are the same. And if not, they do it again. You have to ensure equal access to association media during election votes for election purposes. I'm going to tell you what that means. If a board of directors is in the middle of an election for a grant of common area, amendment to the governing documents, the board is not able to use association media or association funds to be in favor of or against the initiative that is before the membership for a vote. But if they do, it triggers something called equal access. So let's say we're at an association board meeting, it's via Zoom, and the board president says, instead of, hey, everybody, vote, not how you vote, just vote, and says, please vote for this board-supported amendment to the governing documents. A homeowner could claim under the statute and under case law that equal access has been triggered, and the next day submit to the association an email blast to go out to all the members, which you may not edit, that says that they are against this. This is the most horrible thing. This is a totalitarian government running their association, and all the nice things that people say about our volunteer board members. This is a very important thing to be mindful of. I am asking you, please speak with your association's legal counsel about the actual implications negative to the association if this trigger is actually made. We have a community that they cannot get out of their own way, and they're very large, and somebody always says something, and then for the last two things that were before the homeowners, every single day we had pro con, nasty, nastier, nasty, nastier, and it went on and on. Homeowners also have a right to equal access of the association's common area without charge. All of this is in the election rules. So if you have a clubhouse, you charge $100 to rent it plus a deposit for the cleanup, and somebody is making an equal access demand, so they want to proselytize their position on whatever is before the members for a vote, you cannot charge them any fee or cost for using the association's common area. The only exception to that, and I'm going to go out on a limb, is if they damage the association's common area, because there is another provision that specifically says that if an owner is responsible for damage to association common area after a noticed hearing before the board can levy what's called a reimbursement assessment. But all of those things have to be in your election rules. And wait, there's more on the next slide, Stephen.
Right. Your election rules also have to specify the time period during which the inspector has to maintain the registration list and voter list, which is usually going to be a year, which is the statute of limitations for somebody in the association to challenge the election, after which the inspector will turn over those records to the association. The rules have to remind owners that they have the right to verify the accuracy of the information on the candidacy and voter lists at least 30 days before the ballots go out. The rules have to, restate the law, essentially saying that ballots cannot be denied to any member for any reason other than not being a member at the time the ballots were distributed. Just a distinction here. Earlier, we talked about qualifications for directors, and there are some, 5 or 6 qualifications that associations can have. There are no qualifications for being able to vote anymore, except that you must have been a member at the time the ballots were sent out. It doesn't matter whether the person is delinquent in assessments or whether they're in bad standing, or if they've caused damage or whatever. And a lot of bylaws say that you can deny people ballots for those reasons. No longer. That's the only valid reason that you can deny somebody a ballot. And again, you cannot deny a person with a general power of attorney for one of your members from receiving a ballot and then casting that ballot in the election, as long as it is a valid general power of attorney. Sandra, I think the next slide is the last part of the required contents for election rules now.
If your head is not spinning after listening to all these election rules, you're not listening, because my head is spinning, and I worked on this outline and we prepared for this session. It's just so much. So we are reiterating, because this seems to be the weak spot that requires the ballot of a person with a general power of attorney to be able to vote, so that member can be represented by that ballot being voted, and requires the inspector of election to update information changes within 2 business days of receipt. So we send out information to the homeowners and say that we need you to confirm your information, your mailing address, your name, where you want to get your information. And they say, no, what are you talking about? I'm living in my home or my unit on site again. You have to use that address, change that to make sure that they get their ballot. That's the purpose behind this part of the statute. And the inspector has 2 days to do that. I am very concerned that a homeowner inspector may not know that they have that requirement, or may not be able to facilitate that requirement They will, of course, if you are professionally managed, which hopefully you are, they will convey that information to the association's managing agent. And then the last of the rules requires the inspector of the election to deliver or cause to be delivered at least 30 days before an election. So the election is when we are counting the ballots, to send to each member their ballot, a copy of the election rules, or a web address to obtain a copy or to view the election rules, so that you can avoid having to spend the money on the mailings. And remember, you may not amend the election rules within 90 days of the election. If your bylaws require an election in a specific month, you need to calendar the review well in advance to ensure that you comply with the timing provision, the 90 days, but you already know you're going to be dealing with the timing provision anyway if you ever have a hope to actually have an election by acclamation. And our next slide, Stephen, tell us about the inspectors.
Right. So we've heard who the inspector can't be anymore, right? It can't be a director. It can't be somebody who's related to a director. It can't be a candidate. It can't be anybody with the management company. It can't be anybody under contract with the association for anything except for being an inspector. But who are these inspectors? Who can be an inspector now? Well, it has to be an independent third party, and the law makes some suggestions of who might be able to do this type of role. A volunteer poll worker with the county, a licensed CPA, a notary public. Typically, it's going to be a individual or company that specializes in providing inspector of election services to homeowners associations, just because there's so much involved in it. A question that's come up a lot recently is, okay, if we know that we need an inspector at least to figure out whether we're going to be able to conduct an election by acclamation and to send out the call for candidates, review the qualifications, decide if the people are qualified to serve on the board or not. Let's say the association board does vote to have an election by acclamation. How do we pay the inspector? Because they're not going to be doing most of what inspectors typically do in terms of receiving the ballots and counting them anymore, right? So what you're going to want to do is have a contract with the inspector that is twofold, right? Here's the first phase, doing everything up to the point of the close of nominations, and then determining whether the association is going to be able to conduct an election by acclamation. And then if not, doing all of the rest of that in terms of mailing out the ballots, receiving them, verifying the signatures, counting them, things like that. So that's going to require actually looking at the proposal from the inspector and not just signing it on the dotted line or sending it to council and having them look at it. Because otherwise you could possibly have a dispute with the inspector in terms of how much they're entitled to. Remember, the inspector has to be appointed prior to when the ballots are sent out. The law doesn't really say what happens if something happens to the inspector and they're not able to attend the meeting where the ballots are counted. It's most likely you're going to be able to get somebody else to fulfill that role, but at least if you're going to have multiple inspectors, you have to try to appoint them. You have to appoint them at an open session board meeting prior to when the ballots go out. Again, on the next slide, just to remind everyone, the inspector can't be a board member, a candidate for the board, related to a board or candidate member, or anybody who's under any contract with the association. That includes management company, that includes attorneys, although sometimes attorneys do serve as inspectors of election, but usually that's the only thing that they can do for that association, right? Because otherwise they would be under contract for other things as well. It cannot be anybody who has any kind of a business contractual relationship with the association for anything other than just being an inspector. On the next slide. So the law does say that the inspector can be a member of the association, right? And so a lot of associations have said, well, think of how much money we could save. We're a small association. If we don't have to go out and hire one of these companies to do this, and we can get a volunteer from our community to help us with it. Well, on the next slide, one of the first considerations is that there's a significant time commitment that the inspector is going to be having for every election. We estimate around 3 to 3 1/3 hours for every 100 ballots, which is a minute to register the people coming to the election, the annual meeting, a minute to open the ballots, and then to count them and then to tabulate them. So we're looking at 9 hours of work for a 300 unit community. And that's assuming that you have any kind of experience doing this, right? If this is your first time at the rodeo, it could be a lot more than that. And as we'll talk about in just a minute, the duties now that are required of inspectors are so extensive that it's really hard to picture a situation where an association is going to actually be able to rely on a member to fulfill all of those duties in terms of what the law requires of them. And so on the next slide, we have a timeline, which I don't think we're going to go through completely step by step. It is in the materials, but Sandra, I think you're going to talk about that.
So the point of the timeline, it's 2 slides, and I'll get to the second one in just a moment. There are 16 possible steps to meeting the election timeline to have a successful election that is not subject to attack or set aside by court order or board decision. And it's the preliminary, it's the required timelines that we went through for the vote of acclamation, which are rather extensive. On the next slide, we can see that there's more steps for acclamation. This is the inspector of election determines whether or not there are more candidates than the number of seats, or if there are less than or equal to. And then verifying the accuracy of the homeowners and determining ballots, return address, and signatures. It is a lot. I support completely Stephen's comment that it's really for us becoming more and more dangerous and exposing the association to what we worry about, which is legal liability because of all of these required steps. We broke it out this way. This is sort of like a midpoint summary of everything that we've just gone over with you so that you could see this in a form layout. First, we have to do this, then we have to do this. That's the point of the slides, and also to give us a second to breathe. We have now taken a breath, and we're going to go to the next slide, which is the duties of the inspector. So this is really what they have to do. So I already mentioned one of them. They have to get out those ballots 30 days before the election, no less than, to each owner, along with the election rules. So we know that. We have the inspector determine the voter eligibility. They're going to get that information from the managing agent or the board if you are self-managed. You're also, as an inspector of election, your inspector has to hear and decide all votes over voter eligibility. So the management company provided the inspector with the name of the homeowners as of what they call a plant date, a date significantly due in time. If you can turn in ballots up till the day before the election, the plant is going to be the day before. Somebody comes to the election with a wild card deed or a grant deed where somebody expressly conveyed their property to a third party, and the inspector is stuck in having to figure out, what do I do? Do I actually look at this? Is this controlling, or do I deny the acceptance of this ballot? You want to make sure that in your election rules that your inspector, whether it's a homeowner or a company, is authorized to communicate with association legal counsel. I'm not saying that association legal counsel needs to be in attendance at this vote count, but needs to be on call in case the inspector of election has a question, the most important being is disputes over eligibility. You're going to put that process into your association's election rules so that we know how the dispute can be resolved and we don't interfere with the counting of the ballots. We've had situations recently where there was a tie election And the election rules, this was a carryover from their governing documents, said that the election, if there's a tie, can be confirmed by lot. I didn't even know what that meant. I didn't know if it was a lot of property, like in a planned development. Well, apparently lot is a way you determine whether there is a split vote on something. And how do you do that? You do it by flipping a coin, having a short straw. And the inspector of election, in full view of the cameras, so this was a Zoom count of a board meeting, so there was a camera behind the inspector so homeowners could see the envelopes being opened and the ballot, and there was a camera in front. They had a tie. The inspector said, oh, your election rules said this is by lot. We're going to flip a coin, full view of both cameras, so in front of all of the owners, flipped a coin, let everybody see that it was tails, which meant one of the tie persons was going to be elected to the board. And the other homeowner sued and said, because they were not in person, the inspector of election choosing the lot of how they were going to do the tie was improper and violated and exceeded their authority. Can't tell you how that one worked out, since that lawsuit was literally filed and served this week. As I mentioned before, the inspector can also designate helpers who must meet the same qualification. So a helper can't be a management company employee. It cannot be the wife of or the husband or partner of the association corporate office secretary. So we're really limiting the pool of people that can be of assistance. And again, the inspector is going to look at the ballots and determine validity, authenticity, that the exterior envelopes are signed, etc. On the next slide, we have more duties of the inspector. Stephen?
Right, and this really goes to, why volunteer members of the association probably are not going to be great inspectors. The inspector is also responsible for the election by acclamation process, determining if the number of qualified candidates is not more than the number of vacancies in order to proceed with a vote by election by acclamation, which again is done by the board. The inspector makes the recommendation to the board. The board decides if it's actually going to seat these new board members based on that. The inspector hears and determines all challenges regarding the right to vote, which may require consulting with legal counsel, particularly if you're dealing with sort of tricky trust issues. Counting and tabulating all the votes, determining when the polls close, and then determining the tabulated results of the election. The inspector also prepares a report at the end of that, which report the law says is prima facie evidence of the result of the election. What does that mean? It means that if somebody were to challenge, prima facie means it's sufficient on its face. If somebody were to challenge the election, the association would not have the burden of proving the result. The tabulated report that the inspector had prepared would be sufficient on its face to show that this was the result, and therefore the challenger would have the burden of showing, no, this actually was not the result, and it's going to be very difficult to do that, right? That's a high bar.
We want to make sure that all associations, it doesn't matter whether you're using members, whether you're using county poll workers or an election company, should prepare this report so it puts you in the driver's seat, you being board members on behalf of your association, where you don't have to defend the action. The homeowner who's contending that the election was improper, as Stephen just said, has the burden of proving.
Right.
So moving on to the next slide, the inspector may verify the member's information and signature on the outer envelope, and has to retain custody of the sealed ballots. We know at one time with election laws, the inspector hung on to the ballots for 90 days and then the association for 30 days. So we assumed that meant there was a 1 year that somebody could challenge the election. That's tied to a provision of the statute which said just that, but we knew where those ballots were and the election materials during this entire process. Now we are keeping those election materials with the inspector of election, who was a volunteer, who may move after the election, who must be available if somebody wants to see the election materials to be with them while they are reviewing the election materials. So this ongoing obligation does not end when the election is over. It can actually continue for a 1-year period. Imagine that somebody lived in an association where they had a garage and the election materials are in the garage on the floor and they have a flood. And the authenticity of our election materials, which have now been destroyed, are merely the copy of the inspector's report. If somebody is gunning to overturn the election, that is going to be a significant problem. The inspector may designate a location for custody of the ballots. I know many people ask, well, can the inspector direct that the management company obtain the ballots? And this happens frequently when we have members who are the inspector. And I think that to a certain extent, and I think that you agree, Stephen, it really interferes with the intent and the scope of the law. But does it specifically say that you can't do that if the authority is there for you to designate a location for the custody? So the answer is no, it doesn't specifically say, and under no event can those ballots be received by the managing agent. But if you're going to do that, that direction to management should be, this must be in a sealed container. And I'm all about theater art when it comes to elections. Show the ballot box with the hole at the top, show how it's taped, show that the management company wrote their names over the sides, and take a photograph of it, or have a lock on it, and with ceremony, hand the keys to the inspector of election with a dated video. Going through a member challenge to the election can be both time consuming and expensive for the association. So we're just trying to give you tools to work with to do the best you can in dealing with any of these challenges, because the rules are so voluminous. And Stephen, want to bring us home on duties of the inspector? On the next
Yes.
slide.
Yes. So the inspector also has to preserve the confidentiality of the vote. The association is never going to know how anyone actually voted, because they're never going to see the outer envelope and the individual ballots together. But they are going to see that somebody voted, a person submitted a ballot by signing their name on it, or at least an envelope. The inspector has to perform any acts which may be proper to conduct the election with all fairness, and that means, even if it's not listed here, to do other things to make sure that there's a fair election. Consulting with the attorney of the association as necessary. This third bullet point, this, for people who are familiar with fiduciary duties of directors, this is almost the exact same language, that inspectors have to perform their duties impartially, in good faith, to the best of their ability. And so this is essentially just saying that inspectors really, they basically are fiduciaries, right? They're not conducting the election for their own benefit. Everything they're doing is to put the interests of the association first. And again, if you do have a situation where you have 3 direct inspectors, you can have 1 inspector or you can have 3. A decision of any 2 of those is considered a decision of all of the inspectors, and therefore is binding on the election. In the next slide, we talk a little bit about the convoluted issue of cumulative voting and how we're not really big fans of it, but sometimes it is permitted.
So we're not fans of it. How did it wind up in associations' governing documents? They are put in governing documents for developer purposes, so that under the statute, their votes, until certain mechanisms happen with the sales of units or homes or property in an association, they get a 3-to-1 ratio. So every one of their votes is equal to 3 of the members' votes. So they like cumulative voting, so they can control the board and the association for a longer period of time. We always recommend, when associations are amending or restating their governing documents, to remove the cumulative voting requirements, so that we have an ongoing fair playing field, and so that if there's a challenge to the board of directors, that the cumulative voting does not take on, which it can, a life of its own. So we do have an issue with some ambiguities in statutes. And if the election rules state that the votes will be conducted by cumulative voting, can the election rules also remove the requirement that a member must announce his or her intent to accumulate their votes, which is a statutory requirements in one of the statutes? And we really have a difference of opinion between the Corporations Code and the Davis-Sterling Act. And we believe that you can put a provision in the election rules if you do not have cumulative voting, that cumulative voting is not allowed. If you do have cumulative voting in your election rules that allow for it, you can state in the election rules that cumulative voting will be allowed. Or last stop, a board member is still a homeowner, and they at a board meeting can say, I am going to reserve the right to accumulate my votes. And then we will have the one person who is triggering the right of the members to accumulate their votes. On the next slide, secret ballots, we're going to start talking about what these puppies look like and what's required. So a secret ballot is required for voting on assessments where homeowners are required to vote. So that's like for a special assessment or not an emergency assessment, but a special assessment of the members. It is also for a vote where we are selecting or removing our directors, grant of exclusive use common area, which I briefly talked about before, and amendments to the association's governing documents. The statute says that any owner can ask the inspector of election for a receipt for their secret ballot, just like we have in governmental elections when you're given the top part of your tally, that's your receipt, or you can actually ask for a paper or electronic receipt, and you're able to track where your ballot is at any particular time during the governmental process. We like having that. We have prepared a form. Please feel free to ask us for a free copy for your association. We'll send it to you with fill in the blanks so you can customize it, or I'm sure that Connor can post this along with the recorded session of today's presentation. But it's, again, it's another cool tool that you can use to be able to be responsive to the homeowner demand, and they have the right to make that demand. Stephen, let's go to the next slide on secret ballots.
Right, so just like the election rules have to have certain things in them, secret ballots also have to have certain content. When the secret ballots go out, they go out with two envelopes. There's a smaller envelope in which the actual ballot is entered into, and then the larger envelope that the owner signs. And both of those and instructions on how to fill them out have to be sent out not less than 30 days prior to the meeting via first class mail or delivered to each individual member. A voter cannot be identified on any ballot name, on any ballot, including their name, their address, their lot, their parcel, or their unit number. The inspector has the right to throw out essentially ballots that have information on the outer envelope that shows how the ballot within it was cast, or information on the ballot itself that says who cast it. Any of that kind of identifying information, it basically goes against the whole secret ballot process. And so because it taints the election, the inspector has probably the obligation to discard those ballots. Although all ballots that are received are going to count towards quorum, even if the inspector does end up discarding some of them.
And that's because they look at the exterior envelope.
Right.
And so long as that information is filled out and we know that the homeowner hasn't violated that, they can count towards quorum. That's the distinction there.
Right. And then the ballot itself should contain the name of the association, the issues that are being voted on, and then if there is a proposal to amend the governing documents, a text of that proposed amendment. It won't necessarily be the actual amendment that gets recorded with the county, but it'll be the language that is being added to this or taken out of the CCNRs, so that the owners can properly review it and see what the substantive change is being made. On the next slide, the secret ballot has to also tell the members if the bylaws allow for cumulative voting, whether they can accumulate their votes and how many votes that they can cast, which is the number of open seats on the board times the number of so if you own one unit and there's 3 open seats on the board and you have cumulative voting, you would have 3 votes that you can cast any way you want. You can give them all to one candidate. You can split them up among the 3, however you want to do it. But that's what cumulative voting allows for. And again, those ballots received count towards quorum. A lot of older bylaws will say members present in person or by proxy. Well, with a secret ballot, nobody has to be present, right? So in terms of counting for quorum, it's not how many people actually attend the meeting, it's how many ballots are cast for that meeting. That's what goes towards quorum. And then in the next slide, we're just going to talk a little bit about how the COVID pandemic has affected elections and how to still conduct them and for them to be valid.
So as you likely know, and if not, you'll know now, the governor had deemed that the pandemic was an emergency in our state. And because it was deemed an emergency, he levied an emergency order that our meetings can be conducted on web-based software, cloud-based software, electronically, Zoom, GoToMeeting, WebEx, etc. And we've all been concerned about whether or not this will continue after the pandemic becomes an endemic, and hopefully that will be not too far in the future. And we believe there are certain things that we can do in order to still be able to do Zoom meetings. The inspector must be seen, the ballots must be seen electronically. So photographs, ongoing video to the exterior back, so that the members are seeing over the inspector's shoulder and in front, so that there's nobody moving around the ballots, which would be visible if everybody was in person. Board members will also have to vote by roll call. There will be no consent calendars. Do we all agree? Say aye. It has to be Joe, Mary, John, etc. That will vote one by one. You also have to have a designated person to respond to any concerns or any problems that people have in accessing the meeting, whether it be via the web, telephonically, whatever their problem is, somebody who will help them electronically. And the next slide is the opening and counting. The inspector completes the inspection, does the report that we have talked about, certifies the inspection, and gets that information to the association's board of directors, because they promptly must give the board of directors the tally. As we said, we like the inspector report because it creates a irrebuttable presumption. It changes the shift from the association having to defend its action or that it was proper, to the homeowner having to assert it was wrong. And so then they have the weighted burden. So we really like that inspector report. If you haven't done that before, we really ask that you do so. We're going to briefly go through the agenda because it's so similar to our board meetings with certain exclusions, so that we have plenty of time for those 100 questions that we have brewing. So on the next slide, Stephen, if you want to briefly take us through the agenda for the meeting.
Right. So the annual meeting is, it's a meeting of the members, and it needs an agenda so that we know where we are at each step of the meeting. Some bylaws say that you'll use Robert's Rules of Order or some other type of parliamentary procedure for conducting the meeting. But in any case, you want to have the agenda. It starts with the president or chair of the meeting calling the meeting to order, and then announcing whether quorum has been met for the meeting. Quorum, again, if you're doing a secret ballot election, being the number of ballots that were received. If quorum has been met, and this question has come up quite frequently in the time that I've been looking through the chat, what happens if we just cannot get quorum for an election? of directors? Well, you have a few options. Some bylaws say that you can adjourn the meeting, which basically means extending the deadline to vote. Some say you can adjourn the meeting with a lower quorum requirement. But possibly if you've done that multiple times, you could just say the association made a good faith effort to get quorum for the meeting and they weren't able to. And so the current directors are just going to stay on the board until the next meeting. That happens not infrequently. On the next slide, we talk a little bit more about the contents for agenda.
So nominations from the floor, this is an issue that people are concerned about as it relates to acclamation. If your governing documents allow for nominations from the floor, how can we ever agree to acclamation? And the answer is because the legislature has set up this very restrictive process with a lot of benchmarks along the way that allows for acclamation. You're never going to get to the floor because those ballots are not going to be sent out. On number 7, the cumulative voting, depending upon, as we've discussed ad nauseum, the requirements in the association's governing documents and the assertion to say that we're accumulating votes. Worst case scenario, a board member says it as at an open meeting before the ballots are mailed. Best case, it goes into the association's election rules and you amend that puppy out of your documents on a going forward basis. Voting, members are in person by their attendance, by their ballot, or as applicable by proxy. And we're going to count and tabulate the votes by the inspectors. Stephen, do you want to take this last couple of slides?
Yes, so we are on other issues. So the agenda is also going to say that the things that are not required to be conducted via secret ballot, things like the vote on the IRS election of what to do with the excess funds, a vote on whether to allow the board to obtain a loan for an emergency special assessment. Things that don't have to be via the secret ballot process, which are listed in the statute, those can be in any other method. That could be a questionnaire, it can be a voice vote or a show of hands. But if there are other issues that are going to be decided at the annual meeting, those would also be listed on the agenda. And if it's not possible for the inspector to finish the tabulation during the meeting, they can adjourn to a later time to continue that.
And on the next slide, just in a summary, we have to get the results out to the board as soon as possible, and we are required to send the results out to the members in writing within 15 days of the date of the election. And the last slide, Stephen.
Yes, and after you've actually conducted a successful election and now you have a new board, right afterwards will be an organizational meeting where the board will decide the officers of the association. Officers don't run for the board, only candidates run for director, and then the new board then chooses who the officers are going to be at the next meeting: president, vice president, treasurer, secretary, whatever's listed in your bylaws.
David, we're turning it over to you.
Okay, well, thank you so much. We really appreciate it. We're going to be moving into our Q&A portion of the webinar, sponsored by Eugene Berger Management Corporation and Pacific Interwest. We want to thank them for sponsoring the session. A short reminder to vote for your favorite questions by using the thumbs up icon in the Q&A feature. This will help us to prioritize questions. Thank you so much for doing that. So we'll give you a couple seconds here to orient to the Q&A feature. Look for the thumbs up on the left side of the page, and just go ahead and click on that for the questions you think you'd like to have answered the most. And we'll give that a couple seconds while you read those. And we'll go to the very top, most up votes. And that would be, does email count as individual delivery? It's a little change this year, right?
Right. So email counts as individual delivery if the homeowner says it counts as individual delivery. So the member says to you, as you're soliciting information from the members about how they want to be communicated with, if they say we want to be communicated with via email, then that can translate to individual delivery. The effective date operationally on that is January 1st of 2023, but we believe if the owner is telling you this year that they want to be communicated with electronically via email, that you can go ahead and rely on them and do that. However, only if the mailing that goes out to the members telling them that they have the right to elect how they want to be communicated with, if it specifically says you are not obligated to give us your email address.
Okay, that's very helpful. So Karen asks, discuss without permission in Civil Code 4515. If the HOA election flyers are distributed in a neighborhood without permission, can the member who distributed them be disciplined by the board in any way for the distribution?
So the 4515 says that the governing documents shall not prohibit a member from distributing or circulating without prior permission information about the development. Essentially, this just means that homeowners have the right to circulate material critical of the current board management, and that the association cannot necessarily, unless it's harassing or defamatory or something like that, they can't tell them that they can't do that.
Okay. How does an association determine, hold on here. How does an association determine if a prospective board member has a criminal record? Should associations do criminal background checks on prospective board members?
So I saw this question during the presentation. The statute says if an association becomes aware of a criminal conviction, it doesn't say that they have any affirmative obligation to fingerprint everybody running for the board and send it off to the FBI. It just says if they become aware. So I think if they're not aware, then they don't have any further duty in that regard. But if they do learn of something that, and if any one individual board member learns of it, that knowledge is imputed to the rest of the board, then I think they would have a duty to, try to find out more about it and see if it's going to potentially jeopardize their fidelity insurance.
Okay.
So
here,
some associations put in their nomination form a question of, have you been convicted of a felony within the last 5 years? And if the homeowner doesn't answer, or they answer incorrectly, the burden is not put on the association. It goes to the heart of what Stephen just said about if you become aware. And it shows that the board acted in good faith in trying to obtain that information.
that's good. Okay, that's very good. Robert Sullivan asks, if our CC&Rs and rules do not have term limits, do any of the new rules dictate such limits? And we had several questions on term limits for directors. Can you explain that a little bit more?
So a term limit is a qualification. That's why our firm took the position last year when the legislature said what could and could not be mandatory or voluntary qualifications, that the provision in the CC&Rs about term limits would not be able to be enforced. The legislature corrected their mistake and said term limits are now enforceable, but only if they are in your governing documents. And what term limits are is that they'll say in the CC&Rs that, or sometimes in the bylaws, that a director can only serve 2 terms, consecutive terms, or X number of terms, if not consecutive, within a set period of time. So it's deemed a qualification.
Okay, so that's good. Can a current board member running for re-election campaign for himself and endorse other non-current board member candidates?
I would say yes. I mean, the board, the people running for the board have the right to advocate for themselves as candidates. It's more of an issue of if they're going to use association resources to do that. Then it becomes an issue of if once you have, you're not allowed to use association resources essentially, but if you do, then everybody who may be running for the board or who has a point of view has to have access to those same resources themselves.
So as long as the association is not paying for it, and then we're not using, as Stephen said, those resources, the only resource that you can use is just like every other owner asking for the membership list from management if the board doesn't have control over the membership list. I like if a board is going to advocate for themselves on their own dime during the election process, that they actually ask for that membership list, even if they currently have access to it, so that it really interferes with any argument that they were acting improperly.
Scott asks, please clarify, part one, can the management company assist with the preparation of mailing and ballots? And part two, can management company take in and hold the mail in ballots for the inspector of elections?
So as for
So-
part one, the management company can definitely prepare the ballots. But as for the rest of the questions, I would strongly advocate for the inspector to be responsible for actually mailing them out and receiving them. The more the management company is involved in handling them, the more that cannon fodder that somebody's going to have to challenge the election and say that the integrity of the vote was not valid. So although it does happen sometimes that the management company mails them out, but the law really says the inspector's job is to distribute them and to receive them.
Okay, that's I get that question quite a bit actually, and it's sort of a political question as well. If your community has a lot of different factions, you may want to be extremely careful about who collects the ballots and who mails them out, because you don't need to have those issues. Okay, so David Bonfilio says, since many homes are in living trusts, is a power of attorney applicable?
Well, a trust is a method of holding title to property. The property is actually owned by the trustee, but a trustee is not the same thing as a power of attorney. A power of attorney is a written document that gives another person the right to act on your behalf as to certain matters. So when the law talks about somebody who has a valid general power of attorney for a member has the right to receive ballots, that's the type of document they're talking about, is to say, yes, I'm a member of this association, I own property here, but I have given somebody else a power of attorney to receive this ballot for me. It's very similar to a proxy. It's just there's different rules about it. So they're actually kind of two different things.
But on the issue of the trust itself, the trust can designate one person to be the representative for the trust. So that was sort of the second part of that question.
Right, and that representative then votes on during the elections, I assume.
That is correct.
Okay. Okay, does email count as delivery? We talked about that. Here's number 8. Audrey Moy asks, can someone who represents an owner, but they do not reside there, is not an owner, be on the board? So non-owners, can they be on the board?
No, I mean, and residing there is not a qualification anymore. A lot of associations where there's timeshares and things like that, they'll have in their governing documents that you must be a full-time resident, but that's not a qualification that associations can use anymore. If you are not an actual owner in the association and therefore not a member of the association, the association is required to disqualify your candidacy.
Okay. Can anyone represent, let's go here to an anonymous. Can a manager from a management company, but not your manager, act as the inspector of elections if they are a notary? Since the contract would be with the management company as a whole, wouldn't they be also considered under contract?
They would be considered under contract. And I want to go back to just the last question.
Okay, sorry.
There are exceptions for the developer. Yet again, that the developer does not have to be an owner. It would be language that is set out in the governing documents, and the legislature through statute supports their ability to have representation on the association's board of directors during set periods of time.
Okay, so Marcia asks, will the new 323 rules require HOAs to have an attorney rewrite their election rules?
So the election rules should be rewritten to deal with the new requirements. I'm an attorney. I look at that as a legally binding document that is going to affect the association and be used potentially as evidence in litigation. So of course, I'm going to say that an attorney should do it. Does the statute say an attorney must do that? It does not. But I need to be honest. I think you run the same risk that if you go to your dentist and you ask the receptionist to drill out your molar, you're running that same risk. And I don't think that you would do that when you go to the dentist. I wouldn't do it with a legal document.
Yeah, that's a good point, and it's a significant issue, managing risk. Okay, Bruce, and I think we're going to probably take, this will be the last one. Our association allows write-in nominations at the annual meeting. Would this be banned due to the acclamation changes?
This is a really good question. I think the general consensus is nominations from the floor and write-ins are not applicable if you are conducting a valid election by acclamation, because otherwise it kind of defeats the whole purpose, right? That the whole idea is that you only got this many candidates, there's only this many seats. If you're gonna get to that point and say, okay, now the board can seat these people, but then also say, but by the way, does anybody else want to nominate themselves from the floor or write themselves in? It sort of defeats the whole idea of allowing it in the first place, even if the bylaws do allow for it.
Mm-hmm. Okay, thank you so much. I want to thank you for being a member of ECHO, but if you're not, please consider joining. In 2022, ECHO has planned more than 60 online events. In addition, we offer a vast array of resources for boards and HOA members, including personalized guidance on challenging issues and a series of educational programs. Please join to help sustain our efforts. To join, simply visit our website at www.echo-ca.org and click on the membership tab. We are excited to announce the formation of a new and exclusive monthly HOA board members club, exclusively for ECHO members who are HOA board members and former HOA board members. This group is led by two former volunteer HOA board members, Miguel Sanchez and Tom Connolly. They are wonderful, experienced leaders. Please click on the sign-up sheet in the packet or email Patty Curzet at pkurzet@echo-ca.org to become a member of this exclusive and interactive group.